Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 121. I'm conscious there's been a bit of a break. Even partners in city law firms these days get to go on holiday from time to time, and I had a lovely couple of weeks away at the end of August, so I'm absolutely delighted to be back. And if you believe that, I've got a bridge I can sell you while I'm about it. Anyway, the three cases that we have are pretty varied. We've got one on holiday pay, and perhaps that's quite appropriate given what I was just saying about time away from work. However, it really does, I think, clear out some of the sort of residual objections by employers to accepting the need to pay holiday pay correctly. We've then got a really useful case on offshoring and how the transfer regulations apply in those circumstances. And finally, there's a good case on witness orders and the process for applying for them and what happens thereafter. Since witness orders do feature quite frequently, or surprisingly frequently maybe I should say, in tribunal cases, I thought it was worth picking up on this case. As usual, don't forget, you can access our podcast via iTunes, it's the Mayor Brown website, YouTube, Twitter feed, and on Twitter feed, of course, we put out the links to the cases as well. So, where are we going to start? Let's start with Dudley Metropolitan Borough Council and Willets. Of course, as we all know, holiday pay has been one of the more surprisingly controversial areas of employment law over the last few years. Going back to cases such as Williams and British Airways, the European Court of Justice has indicated that the right to take paid holiday leave requires the employee to be entitled to receive their normal remuneration during the holiday period. Otherwise, there would be a disincentive for the individual, the employee, to take holiday. The European Court, in the Williams case, has said that where there was an intrinsic link between the payment and the task which the individual was required to carry out, then that would form part of a normal remuneration. In other words, intrinsic link with the work the individual was required to carry out. But did they actually mean this? We're about to find out. Of course, this formulation rather begs the question of what happens about voluntary work. It's one thing to identify an obligation to pay, for example, commission, which was contractual and where the individual was required to undertake the work in question under the contract of employment. The idea of an intrinsic link to work which the employee is required to do, that functions perfectly well. But what happens if the individual is not required to undertake the work, but does so on a voluntary basis and gets paid for it? Well, this case gives us the answer, at least in the opinion of the EAT. It's very clear in its ruling that the claimants were quick response operatives for the council, including electricians, plumbers, roofers, etc. They'd set contractual hours which concluded a contractual right to a certain amount of overtime pay, and there was no dispute about this, none of that was controversial, and those overtime payments, the contractual ones, were being included in holiday pay by the council. However, in addition, these individuals also volunteered to undertake certain additional duties. There was a rota, and the Employment Tribunal decided this additional work by rota was, quote, almost entirely at the whim of the employee, unquote. In other words, there was no dispute about it being truly voluntary. As part of what they were doing when they were doing the additional hours, there was an out-of-hours standby payment, call allowance and voluntary overtime pay. The Employment Tribunal decided that generally these items should be included in the calculation for holiday pay. In other words, the fact that work was done voluntarily, albeit in return for pay, did not take it outside the scope of holiday pay when it was being calculated properly. The out-of-hours standby payment, for example, had been paid over a number of years, but was in practice tended to only be paid 1 week in 4 or 1 week in 5 during that period, i.e. when the employee was on the rota. The Employment Tribunal decided the key thing was to look at what the individual's normal pay amounted to, irrespective of whether this derived from a contractual obligation or a voluntary acceptance of additional work. On that basis, almost all of the test cases succeeded. There was one exception where the claimant candidly accepted that he, quote, very rarely, unquote, worked overtime. And so the Employment Tribunal said that in those circumstances the overtime payment could not be part of his normal pay if it was very rare. So those are the parameters, if you like. Well, the council appealed, saying the Employment Tribunal had made an error. Their primary argument was that in the Williams case, the European Court had referred to the need for an intrinsic link between the payment and the performance of the task the worker was required to carry out. Therefore, the council's appeal ran, in summary, if individuals are not required to carry out tasks under the contract of employment but are doing so on a voluntary basis, then it was not intrinsically linked to the compulsory work under the contract, and the nature of the payment meant that it should not be included in the holiday pay. In other words, back to did the European Court mean what it said? Well, perhaps as you'd expect, given the general thrust of the cases, this argument was met with little support at the EAT level. The payments were paid regularly, and the EAT accepted that normal pay, which was the test for holiday pay, is pay that is normally received. No more, no less. Clearly there will become a point where payments are paid so rarely that they are not normal, but that's a question of fact for the tribunal. The EAT accepted that this tribunal had been entitled to come to the decision it had on the relevant allowances and payments. Moreover, had it been necessary for there to be an intrinsic link, they would have said there was an intrinsic link by virtue of the fact that the employees were doing the work, by virtue of being employees, and that once they'd accepted that they were doing the work, they were then obliged to see it through to the end. That was rather a fallback point, though. Given the standby payments were only paid 1 week in 4 or 1 week in 5, the council also argued there was a difference between normal pay and regular pay. Normal pay should only be pay that was paid in the majority of weeks in question. In other words, according to the council, a payment could be regular but not normal if it was paid less than half the time, and therefore the council argued that payments that are paid less than half the time should not be included in holiday pay. The EAT did not accept this either. If the payment was paid on a regular basis, then it would form part of normal pay. If it's only regularly paid once every 4 or 5 weeks, then the fact that normal pay is averaged over a 12-week period would be reflected in the calculation of holiday pay. As I said at the start of the introduction, I think this case does make convincing reading, and certainly I'd expect many employers who have been waiting to see which way the courts will go on the issue of voluntary work will accept that it does now increasingly look that holiday pay does need to be calculated, taking into account pay for voluntary work as well as contractual work. There will clearly be some discussions as to whether the payments are made sufficiently regularly to qualify as part of holiday pay. Equally, it's important to bear in mind that we are only talking about the European leave, the mandatory leave element of paid annual leave. This is, of course, the 4-week period mandated as the minimum under European law. In Britain, we have a full-time equivalent of 5.6 weeks annual leave. And in this case, and generally, there doesn't seem to be any significant dispute that the European Court decisions on holiday pay only relate to the European minimum 4-week period. It's therefore possible that individuals will have a right to enhanced holiday pay for 4 weeks, but under the remaining period of leave, part of which will be UK statutory and part of which would be granted as a matter of employer discretion or contract, individuals would have a right to less holiday pay. So that's the case of Dudley Metropolitan Borough Council and Willits. Next up, Xerox Business Services Philippines Inc. Limited and ZEB. On a number of occasions, we've been asked to advise on whether TUPE or the ARD applies where a business is being offshored to a location outside the European Union. After the case of Hollis Metal Industries Limited and EMB, decided nearly 10 years ago, the orthodox response is there can be a TUPE transfer if the business is based in the UK to start with, although it's possible that a business would be changed sufficiently by the process of being offshored that it was no longer a recognisable continuation of the business that had been run onshore. All very logical, all very sensible. But it does throw up certain issues in practice. What we've tended to find is that where a business is being offshored, it's extremely unusual for the contractual mobility clauses to permit the transferring employer to require the individual employees in the transferring business to move to the offshore location. Conversely, there's no obligation on the employer to provide relocation assistance and so on if someone does want to relocate. You cannot make the staff compulsory redundant ahead of the transfer because that is almost certainly going to be very expensive. It's going to be automatic unfair dismissal. And the transferee, who can make the redundancies after the transfer, does not want the hassle of making redundancies after the transfer as its first act as the new employer. Therefore, most employers opt to offer voluntary redundancy ahead of the transfer, and almost all employees take that up by signing appropriate settlement documentation and often opting out of the transfer itself. On 1 or 2 occasions, for example, we've had offshoring to India, where individuals have indicated a willingness to transfer with the business. This in practice has led nowhere, particularly if the employer points out that once an individual has relocated at their own expense to India, presumably their employment rights would be governed by Indian law, and that may well provide less protection following a TUPE transfer than English law. However, in this case, the Zeb case, we have a rare example of the court actually having to grapple with a TUPE transfer offshore and how it works. It's also interesting that in many ways an odd set of facts absolutely forced the court to address this specifically, given that it's often able to sidestep the issue. The background was that the claimant worked for Xerox UK Limited. Contract of employment said his work location was to be Leeds or Wakefield, and in 2014 there was a transfer of the business from Xerox UK to Xerox Philippines. It was accepted by all and sundry there was a transfer of an undertakings transfer. This was not in dispute, and oddly, the same number of jobs were going to exist in the Philippines as had existed previously in Wakefield, which I think is quite unusual for an offshoring. Anyway, Xerox, ahead of the transfer, Xerox UK gave each employee a choice. If they opted out of the transfer, they would receive enhanced redundancy pay. If they transferred to employment with Xerox Philippines, albeit still based in Wakefield, they'd be made redundant right after the transfer because the business, it was the finance team I think, would have moved from Wakefield to the Philippines. Claimant took the view that he was willing to move to the Philippines and said so, but he also said it would have to be on his existing terms. His employer refused to employ him in the Philippines on his existing terms, but would have been prepared to employ him on local terms, and told him this. So the claimant refused to back down, and on that basis he was dismissed and made redundant by Xerox Philippines immediately after transfer, and he claimed unfair dismissal. He said he was entitled to transfer to the Philippines with his work on existing T's and C's. On that basis, he claimed the dismissal was not for redundancy, and moreover, there was no proper consultation or appeal process or offer of suitable employment. Xerox Philippines, who, as I say, were his employer by the time of dismissal, said the dismissal was by reason of redundancy and that it was fair. Well, the Employment Tribunal upheld the claimant's claim, saying he was not dismissed for redundancy because the reason he was dismissed was that Xerox did not want him to work in Manila, in the Philippines, on his existing terms. Secondly, the tribunal decided there had been a variation of his place of work so that he was entitled to work in Manila. Hardly surprisingly, Xerox Philippines appealed, and the EAT thought that both the tribunal's conclusions were wrong, but it's how they went about it and also their observations on this issue that I think are helpful. EAT went back to first principles. The employee's protection derived from the Employment Rights Act and his right not to be unfairly dismissed. That's section 98. Redundancy is a potentially fair reason for dismissal. The definition of redundancy is contained in section 139, and redundancy definition includes where the employee is dismissed because the requirements for employees to carry out work at the place where the employee is employed have ceased or diminished. And the EAT decided the starting point was to consider whether the dismissal fitted the definition of redundancy. They accepted there was a TUPE transfer to Xerox Philippines. Xerox Philippines moved the business offshore. At that point, when the employee was dismissed, the definition of redundancy was met because there was a reduction in the number of employees required to carry out work at the place where the employee was employed. There was no Xerox finance function left in Wakefield for the individual to work in. However, the EAT pointed out the employment judge and the parties themselves should have focused on Regulation 7 of the transfer regulations. This provides, in general, that if an employee is dismissed and the sole or principal reason for the dismissal is a TUPE transfer, that dismissal is automatically unfair unless there is an economic or organisational reason entailing a change in the workforce. This, of course, is the well-known ETO reason. For these purposes, where the ETO reason definition refers to changes in the workforce, this, according to the regulations, includes a change in the place where employees are employed by the employer to carry out the business of the employer. In other words, an ETO change in the workforce may be a change of the workforce's location, as well as it being a change in the number of employees or a significant alteration to the roles which they are undertaking. Where there is an ETO reason, the ordinary unfair dismissal rules apply, and the employee may either be redundant, if his dismissal comes within the definition of redundancy, or if the dismissal is for an ETO reason but it doesn't fit the definition of redundancy, then the dismissal may be treated as some other substantial reason dismissal. Either gateway gets you to the point, then the dismissal is evaluated for ordinary unfair dismissal principles. So where does this leave matters? Well, firstly, it's interesting you had a case that was so clearly going to force the courts, the employment tribunals, to decide what happened on an ARD transfer where the business is being offshored. Secondly, I think many people would, without thinking about it, have assumed that the employee had the right to transfer on existing terms and conditions out to Manila. Indeed, it was very clear that the main reason for refusing him to transfer to Manila was the employer did not want him on existing terms and conditions out there. What is interesting about this case is the courts seem essentially to have lent their support to the employer's approach. The employee was entitled to be employed in Wakefield on its existing terms and conditions, they said. The AT said he had no right to vary his contract to go and work in the Philippines on his existing terms and conditions. Therefore, the employer could in effect put the employee to a choice: either accept worse terms and conditions in the Philippines or be made redundant. If that's right, that does seem to indicate that employers can be pretty unhelpful to employees who say they want to transfer with an offshoring business. We would probably have said before this case that you should consider whether someone should be allowed to transfer on their own terms and then address the resulting employment contract under the law, in this case, in the Philippines. But what I want to know is what's to stop the logic of this case applying to a transfer within Britain? Could an employer take the same approach and say that a transfer of business based in, let's say, Woking to, let's say, Wakefield, the employer is entitled to offer different terms? Can the employer now say it's on the basis that an employee would be made redundant in Woking unless the employee agrees to transfer on worse terms and conditions to Wakefield? Unless the employee in my hypothetical example, had a significant ambit in their contractual mobility clause, the move would still be outside the boundaries of where the employer could require the employee to relocate to. The redundancy test would still seem to be met, and the main avenue for challenge would seem to be to say that it was unreasonable for a UK employer to adopt a requirement to move on worse terms within the same country. But that's a difference in fact, that's not really a difference in law. And it's going to be interesting to see if outsourcing, which involves relocation, does see transferees trying to rely on this case to knock terms and conditions down for employees who would otherwise be willing to move outside the scope of their relocation clause. So that's the case of Xerox Business Services Philippines Inc. Limited, deep breath, and Zeb. Third and final case, Jones and the Secretary of State for Business, Innovation and Skills. And this is a case dealing with the process for making witness orders, or more precisely, the process once a witness order has been made. It may help to talk a little about circumstances in which witness orders get made before explaining the significance of this case. As a general rule, of course, witnesses attend a tribunal voluntarily. Parties to a case will have to provide a written statement of the evidence of the witnesses they are intending to call. However, in some circumstances it may be necessary to obtain a witness order from the employment tribunal to secure the attendance of a witness. Obviously, it becomes a matter of a potential criminal sanction if a witness disregards a formal witness order. In some cases, a friendly and cooperative witness will be subject to a witness order because it makes it easier for them to attend. For example, if a witness has gone to work for a new employer, it may be easier to secure their attendance if they are able to say to their new employer, "Sorry, I've got a witness order, I've got to go attend this tribunal hearing." Equally, however, there may be circumstances where a party wishes to call a witness who does not want to be part of a tribunal hearing. In those circumstances, a party may weigh up the balance between having no evidence from a particular witness and having the witness attend to give evidence, but may possibly be unhelpful, especially if the witness feels aggrieved about being forced to attend the tribunal hearing in the first place. Generally, of course, it's a very balanced decision, a careful decision as to whether you prefer to have an unhappy and potentially unhelpful witness give evidence on your side or no evidence at all. However, since a witness cannot be compelled to give a witness statement ahead of the hearing, it is then possible for a witness to be required to attend by means of a witness order without having given a witness statement. Now, obviously, this may prove challenging when it comes to trying to have a fair hearing. Well, in this particular case, the matter concerned a claim by an individual, Mr. Jones, who had been an employee of a company which went into insolvent administration, and as such, well, he claimed the Secretary of State was under an obligation to pick up some of the costs for his employment claims from the Insolvency Fund. Fine. The issue turned on whether or not he was an employee, and it seems that the Secretary of State took the view the individual was not an employee of the relevant company, and this was partly in its position in reliance on a draft witness statement obtained from a Ms. Thwaites, a former employee of the company in question. She gave a draft witness statement, and that was in turn disclosed in draft to Mr. Jones. He had, in turn, a number of witnesses who were going to attend the tribunal hearing, including a Miss Coulson, who had said that he was an employee. Well, it became apparent that Ms. Thwaites was being a little difficult on the subject of attending the tribunal hearing, for whatever reason. And indeed, at one point, and I don't quite understand how this came around, Mr. Jones himself provided a contact address for Ms. Thwaites to the Secretary of State. Anyway, in the meantime, Ms. Coulson, whose evidence supported Ms. Jones, also found that she was not going to be available. Well, without disclosing anything to Mr. Jones, the Secretary of State applied for a witness order against Ms. Thwaites, requiring her to attend the tribunal hearing. Pausing here, there's nothing wrong in the Secretary of State applying for a witness order without notice to the other side, because the tribunal rules permit such an application to be made without notice to the other side. But her witness statement had not been included in the witness bundle, the signed witness bundle that was being exchanged, because she never signed it. Mr. Jones was aware of the content of the draft witness statement because he'd been sent a copy as an unsigned draft, but she was not down in the bundle of witness statements that were exchanged. Tribunal makes the witness order for Ms. Thwaites and only sends the witness order to Ms. Thwaites and the respondent. In other words, the claimant was legitimately and completely unaware until the first day of the hearing that Ms. Thwaites had been ordered to attend. As such, it seems to have been clear, according to the AT at least, that the claimant, who was legally unrepresented, was caught by surprise. He had legitimately understood that Ms. Thwaites was not attending. Moreover, his own witness, Ms. Coulson, who was unable to attend, had given a written signed statement, but this was disregarded by the tribunal judge because she didn't attend the hearing, and attempts to find out why she could not attend the hearing during the hearing itself didn't succeed in making contact with her. And we've all had cases where a tribunal has attached very little significance to a witness who cannot or does not attend the tribunal hearing to be questioned, but gives a written statement. And overall, the tribunal judge ruled against Mr. Jones on his claim. At the appeal, however, the EAT agreed there had been significant procedural irregularity. It was wrong for the tribunal not to have notified Mr. Jones that a witness order had been made for Ms. Thwaites, and in the context of this case, it would have allowed Mr. Jones the opportunity to seek a similar order from Ms. Coulson or otherwise secure her attendance. It would also have enabled him to prepare his case, knowing that Ms. Thwaites would be attending to be cross-examined. Since her witness statement had not been in the bundle of witness statements exchanged by the parties, he had every reason to believe she would not be attending. The AT did indicate that in certain circumstances it might be appropriate to conceal from one party that a witness order had been made. For example, there might be intimidation of a witness if it became known that a witness order had been made, but the AT of course said it didn't need to decide that point here because there's no suggestion of that in this case. Overall, I think the case is very logical, and it certainly assists both parties to know in general terms where witness orders have been made. Will mean a change in tribunal procedure, and if a party is making an application for a witness order, then it must take into account that the consequence of doing so is the other side will be told about the order, and the other side may start to wonder and indeed investigate why such an order was necessary. Bear in mind too, of course, there's no property in a witness. Note, however, the case doesn't do anything about the other difficulty, which is that witness orders can be made without the other side being aware of the application or having a chance to object to the witness order being made. Equally, it's sometimes very difficult for the opposing party to litigation to object to a witness order being made, even if it is, as is so often the case, made against one of that party's own employees. So, typically, employees subpoenas a member of management to come to a tribunal hearing to give what the employee asserts as relevant evidence. The first the employer may know about it is after the witness order has been made. The employer may take the view that the evidence is of limited relevance, and it may often be very inconvenient to require the manager to attend. We've tended to take the view, rightly or wrongly, that if the witness order is to be contested, it probably needs to be for the manager concerned who is to lead the challenge to the order. Although, of course, the employer has to make it clear to the manager, in my example, that he or she can, of course, choose to give evidence if they so wish. In other words, you want to be quite careful about directing the manager that they must oppose the application, in case that crosses any lines. So, that's the case of Jones and the Secretary of State for Business, Innovation and Skills. So, thank you very much for listening. In all seriousness, it is lovely to be back. I'm back doing these podcasts again. I'm conscious that there's been a bit of a gap, but since my festival-going summer has come to an end and my holidays are now past, we will be back doing the podcasts on a regular basis. Both this and I do hope some more guest episodes. And if anyone has any interest in suggesting topics for a guest episode, I'd be all ears. I'm keen to keep the guest episode going because I think it's often quite interesting to hear about stuff around the edges of employment law and matters adjacent to employment law but that affect all our jobs. So, once again, thank you very much indeed. Take care, and here's to podcast episode 122.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.